Good morning, everybody. Afternoon, I guess, depending on where you are. Welcome to another episode of the Justice Revolution. I'm your host, James the Patriot. Today is August the 3rd in the year of our Lord 2023. I have my ever so faithful co-host, Erica, with us. Say hello, Erica.
Hey, guys.
So Justice will not be joining us today. She had some other things come up. So apologize that she's not able to join us, but we've got a good show. We've got some good stuff to talk about today. A lot has been happening. I mean, Erica's got gobs of stuff to talk about. I mean, she wasn't able to join us last time because of what was it, flooding or?
Yeah, our septic
Yes.
It caused some really gross things to happen, and
Yeah.
I had to vacate the premises for a while.
Yeah. I wouldn't wish a septic problem on anybody. That doesn't sound very good at all. So anyway, I've got some new things to discuss with everybody. I'm going to talk about some things that I've been doing. Anyway, a lot to get into. But before we get started on the topic at hand, which the topic of our show today is traffic stops. You know, what to do when you're pulled over by a police officer. How do you handle yourself? We're going to talk about that in a way. Basically, when I say we, I mean, this is what I would do if it were me. And you guys take it for what it's worth. You can do what you want. I'm just going to tell you, in light of recent events, things are getting out of hand, and we need to really be the cooler heads that prevail in the proverbial room, if you guys know what I mean. So we'll talk a little bit more about that. But first, Erica, let's talk about you. You said you got some big news. Fill us in on where you are. Did you get your septic problem taken care of?
Oh yeah, everything. Well, we've got projects galore. Every day we've got like something that needs to be done, because in order to do one thing, you got to do 20 things before you can do the one thing. So it's like we've got a constant list of things, but it's so fun. It's so beautiful here. It's really coming together. And every day I'm eating from the earth and foraging medicine and different ways to eat things and prepare things. And it's really exciting, some of the projects we're working on. But the natural health aspect, I was telling you, I had developed some skin cancer on my face. I think I didn't go to a doctor, of course, because I don't do that sort of thing, but I identified it for years as a nurse. So I'm about 99% sure that it was some forming skin cancer. And I ended up treating it with just some castor oil. I mixed up a little jar of castor oil, cayenne pepper, and some frankincense oil, and applied it in over a 2-week period. And I kept a Band-Aid over it. Now it's totally gone. You can see there's a tiny...
So it was right. Okay, so it was right there next to your eye. Yeah.
Yeah, that's awesome. Totally gone. It's just completely healed. So everyone I was talking to was like, are you going to go see a doc? Why on earth would I do that? Yeah. Everything that we need for our healing, the body wants to heal itself. We just have to get the right conditions. So yeah,
it does. I mean, it's, you know, to your point, right, is these cancer cells thrive in environments where they have the fuel to thrive on. So why do you think so much of our food is full of artificial sugars, sweeteners, things of that nature? I mean, people just they just think these things are, oh, well, it doesn't have any calories. It's got to be good for me.
And sometimes it just happens like out of the weirdness of, I don't know, back a couple of weeks ago when we had these wildfires from Canada, that's what they were telling us. I don't know. Did anybody else have any terrible headaches? I had terrible headaches for those couple of days. And then about a week after that, I had a major detox of my body where I felt like I had the flu, and I never get sick. So definitely my body was trying to process something. But I eat a really healthy diet. I have very good, I stay hydrated. I do all the right things. And somehow still this thing developed on my face. So you just never know. We live in a fallen world. So
yeah, the environment we live in, I mean, it's no surprise, right? I mean, you look back at figures of the biblical times and how long they lived. I mean, my gosh, Noah was how old? 800 years. Can you imagine a human being living that long now? I mean, we see these people who live in where it's part of Japan. Why am I thinking of the name of that island?
Okinawa.
Okinawa, yes, Okinawa, where all they eat is they eat just the foods that are there, and they don't eat the processed sugars and stuff like that. And those people average, I think, 105, 107 years old, something like that. I mean, they're all centurions where they're reaching 100 years of age. It really is. It's our environment that we're exposed to. It's the constant chemicals. Again, we're getting off into a tangent here. I just wanted Erica to share. But here's the thing, though, you guys: cayenne pepper. How awesome is that? I mean, that's not just something to spice your food.
I gave it to a friend who was having a heart attack, and it dilated her blood vessels.
Yes. So my good friend
on cayenne pepper, you can take a bucket of it and
you can. So my good friend Alina Erickson, you guys know Alina. She is a master herbalist, and I'm gonna butcher this, and Alina, if you're watching, I'm sorry, I apologize. I don't remember if it was her dad or her father-in-law or somebody. It was somebody in her family was having a heart attack, and they said, "Give them the cayenne pepper." He took like 2 or 3 spoonfuls of this stuff with some water, and that's ultimately when it ended up saving. Because cayenne pepper, what does it do to the blood exactly, Erica?
It dilates the blood vessels. So
yes.
it takes what was a narrow space and like pumps it open. So it's kind of like nitro.
So that brings up here's an interesting thing. I'm just going to throw this out to you, okay? So, and I have no shame in this. Apparently, this is a recognized disability now, but I have been a migraine sufferer since I was 11. So, do you think a cayenne pepper pill could potentially alleviate headaches if that's what it does? Is it dilates? Because that's what migraines are, or really headaches in general, are constrictions of the blood vessels in the head, are they not?
I mean, well, not all the time. There can be underlying dietary issues that are causing it too,
sure.
And just different lifestyle things that do it. But I do make some tinctures that address some migraine, so I'll send you one.
Yes, please do. Why have you been holding out on me? Jeez, come on.
I've just been in the woods. Like,
you have.
Foraging and making medicine. I don't get around.
You have been playing Annie Oakley, that's for sure.
Yeah.
Oh, gosh. Hey, Alaska grown. Awesome. We got somebody from Alaska. That's all. And I don't know if you're here in the lower 48 or if you're in Alaska. If you're in Alaska, fantastic. We love to have you. C to AZ, always glad to see you're here. Jen and Chris, for real. Thank you. All right, you guys, let's get into some exciting new developments, I should say. So for those of you who have been following along on Telegram, maybe you have or maybe you haven't, but Alphonse has filed his lawsuit, as you guys know. The other side filed a motion to dismiss. Excuse me. Which I wasn't surprised on. And this has happened to me a couple of times now, where we've filed suit and the other side files a motion to dismiss. So what are we to do? Right? So what does Dr. Graves say we should do when it comes to our lawsuits? What's the process? What should we do? Well, he talks about, hey, this is yours. You need to move to court. If you want to get a ruling on something, you need to move to court. So what do you do if the opposing party is the one that filed the motion, but they're refusing to move to court? Isn't that a delay tactic? Would you say, Erica, that's a delay tactic?
Yeah.
Okay. So there is actually something we can do. So, and I wish, again, this is why I say we're always learning, right? I wish I would have known this sooner, but hey, now I know it moving forward. But this is what you can do. Even though they have filed a motion to dismiss, they are still under the obligation to answer the complaint. Now, what typically happens when the court rules on the motion to dismiss, and let's say they deny it, as they should, now they have 14 days from that denial to file an answer to your complaint. So this is that delay thing that these defendants or these stupid liars, these attorneys for these defendants are doing. They're like, well, hey, the best we can do is kick this can down the road a couple of years, knowing that the courts are bogged down and they're going to take forever. So how do we get this ruling in front? How do we make this happen? Well, Alphonse recently just posted, and I'm sharing it here on my screen. Alphonse recently posted that he is filing a motion for summary judgment. So you actually can, if the motion to dismiss talks about things that are outside the four corners of your complaint, meaning it's not within your complaint, then by rule, the court must treat that motion as one for summary judgment. So why not beat him to the punch? If you know you've got a winnable case, if you know the facts are on your side, the law is on your side, there's no defense that these people can have, why not slap them upside the face with a summary judgment?
Alphonse
right?
Not messing around. He just
not messing around. Exactly. So this is exactly what Alphonse has done. And he's asking for summary judgment / default for failure to timely answer plaintiff's complaint pursuant to this rule. Now, this rule here, 8B, I looked it up. Now, his defendants are state actors. This rule here talks about how complaints against the United States, how they have 60 days to file an answer. He still gave them the 60 days before he filed this. You didn't even have to do that. The minute you get a motion to dismiss that you know is frivolous and you reply back to it, they send their reply brief, maybe you give it another week or so. If they haven't set that motion for hearing, you can file one of these and put them on their heels, which is exactly what he's done. So he's got some interesting cases cited here, and I haven't looked these up to verify, but I'm pretty sure, Alphonse isn't going to put something in a motion that's not verifiable. So this first case here, it's well established that a district court has the authority to enter default judgment for failure to comply with its orders or rules of procedure. Well, we already know that. That wasn't the one that really caught my attention. The one that caught my attention is this one right here, where he says the defendants have failed to defend this case. The entry of default is a deterrent to defendants that choose to delay as part of their litigation strategy. Accordingly, the entry of default allows a court to enforce compliance with the federal rules of civil procedure, which in turn allows the court to maintain an orderly and efficient judicial system. This enforcement is consistent with how the federal rules of civil procedure should be construed and administered to secure the just, speedy, and inexpensive determination of every action and proceeding. This is the thing right here. Defendants that choose to delay as part of their litigation strategy. That's every single one of these defendants that file a motion to dismiss that's frivolous on its face. And that's exactly what Alphonse talks about. Here in his facts, he says they have failed to move the court for a hearing. They have failed to serve a responsive pleading. Their motion to dismiss is clearly erroneous and frivolous, and it's filed in bad faith solely for the purpose to delay and stall the progress of this litigation. Here's another really good case that he cites. A default judgment's purpose is to protect the diligent party's rights. When the adversary process is halted due to an essentially unresponsive defendant, a default judgment is available, protecting the plaintiff from undue delay harassment. That's exactly what's going on. So I just wanted to share that because that's where Alphonse is with his case. So I'm going to bring you up to speed with where I am at, because C to AZ, how's my tort claim going? I'm glad you asked. I'm going there next. So I still haven't received anything. Zero. Not one thing from the county. So I gave them the option, right? I said, I'm going to be the adult in the room. I'm going to play the administrative card. Do something here. They had 60 days. They have 60 days. 60 days is up this coming Monday, August the 7th. So I have heard nothing. I've gotten no phone calls, no emails, nothing in the mail, nothing responding. So what I'm going to do from here is I'll give them till Monday. Nothing comes on Monday. Tuesday, I'm marching myself down to the courthouse and filing my complaint. I've also taken the liberty of adding in my complaint, and let me open it up here so you guys can see, because this is one of the things I don't want these people to have any chance at all for coming back and saying, well, you didn't do this, you didn't do this, right? So I'm going to show you what I came up with here. Okay, so here's my complaint, and I've shared this, you guys. This is in the group. Just remember, when you get to this point, if you start filing these things, and if these guys want to settle it, they're going to make us take this stuff down. So I would highly suggest, before it gets to that point, you guys download this and you have it for reference. Okay, so I used Alphonse's complaint as a template. Now mine is only 43 pages long. Alphonse's is over 100. I'm of the opinion, this is my personal opinion. I feel like less is more. If I can get my point across in fewer pages, I think that's better, for not only for me, but for the court, for everyone else involved. So I'm just going to scroll through this real quick. I want to get to the meat and the bones. Under the facts relevant to all claims. I got down here to, let's see where it is, where I added in the fact that I gave them an opportunity. Here it is right here. Okay. So starting on page 16 of my complaint, I added, on June 7th, plaintiff hand-delivered a notice of tort claim along with a copy of this suit to the clerk's office, as is required under the provisions of this Utah code. Now, again, are we the people bound to do what the Utah code says, Erica?
No.
Or any code for that matter? No, we're not. Exactly. This code is to govern the actions of employees or people of the administration. However, because I don't want these people to come back and try and use that, because again, where do these attorneys live? They live in the code, right?
Statutory land. Statutory
everything. They're like, well, the statutory this, the statutory that. I mean, they wouldn't know a constitutional right if it slapped them in the face.
Right.
Most of the time. So anyway, I'm giving him this option, right? And I'm going to attach a copy of my notice of tort claim where it states, my notice of tort claim, I put in there, I am willing to settle this for this much. If they choose to ignore that, do you guys know what the ramifications are of that with their insurance companies?
Right.
Because once this suit is filed, they're required to notify their insurance company. And the insurance company is going to get a copy of the suit along with all the exhibits. And they're going to see, wait a second, he gave you guys an opportunity to at least try to do something beforehand and you chose not to. That is not going to bode well for them with their insurance company. So again, I added in these extra lines right here. According to this statute, defendants in this case had 60 days to file an administrative response. As of the date of this filing, no response has been received. Administrative remedy has been exhausted. Additionally, in accordance with the provisions of the statute, plaintiff now has the right to file suit with this court. Defendants cannot claim qualified immunity as an affirmative defense as a result of their failure to respond to plaintiff administratively pursuant to the provisions. They can't claim qualified immunity anyway because they're committing crimes. But still, I wanted to put this in here. I just wanted to pull the rug right up from underneath of them. So that's where that sits, so everyone's aware. Let's go ahead and close that. So my next step is next Tuesday. It's going to be a day down at the federal courthouse for me. I'm going to be taking all of my stuff and filing my suit. I'm going to print it off here on my printer, get everything going, get all of my exhibits, take those down to the courthouse, get it filed, and then I will have it served on the defendants probably on Wednesday. So that's where that is. Any questions on that, Erica or anybody else? Pretty straightforward. Sorry, I had to wet my whistle there. All right, let's talk about, so there's that. Now, I want to talk a little bit more about, some of you have been asking about what I've been doing with the internal so-and-so. You know who I'm talking about. The 3 capital letters that everybody loves to hate besides the other one. What I did yesterday is I wrote up a couple of letters. And actually, I'm going to share this instead. Let me cancel that. So this document here is shared in, and just for those of you who are listening, I am sharing my screen, and I am sharing Secrets of the Legal Industry by Richard Cornforth. Love the stuff that Richard Cornforth does. Okay. And then C to AZ. So my tort claim, it's getting up there. So your tort claim is now an exhibit? Yes. My tort claim notice is now an exhibit. How are you going to hide from that? That doesn't look well, right? When you file that claim with the court, it doesn't look well. So anyway, all right. So moving back on to where I'm talking about. So there is a section in this book, Secrets of the Legal Industry by Richard Cornforth, and it's titled Section 8, Attacking the Internal Revenue Service. How long will you allow the IRS to continue to interfere in your life? So this has been a hot topic. We've talked about this before. There's a number of things in here. However, there's 3 things you need to know when you're, and I'm talking about like in my case where my employer has unlawfully withheld money from me and have sent it to the IRS. I don't want them to do that, but they're doing it anyway. So how can I get that money back? Well, the courts have said in order to have standing to sue the United States for IRS misconduct, administrative remedies must be exhausted. Here they are. Number 1, dispute the tax obligation. Number 2, mitigate damages. Number 3, request a refund. So how do we go about doing that? Well, you can actually accomplish all 3 of these things at the same time with 2 letters. Most of you know, in my case, I have been going back and forth with minions working for the IRS, for lack of a better term, and I've been getting nowhere fast. The last letter I got was we needed 60 days to review, blah, 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 blah. It's now been over 100 days since I got that letter. I've got nothing from them. I'm done. I'm done dealing with these.
In the graveyard of paperwork.
Exactly. I'm done dealing with these jokers. Okay. So my next 2 letters, which are going to go out in the mail today, I am sending to the Internal Revenue Commissioner. So again, when this was written, this Charles Rossetti was the commissioner. He's not the commissioner now. It's actually Danny Werfel is the guy's name. So you can find this information. Just do a quick Google search, IRS commissioner, and you'll find it. But everything else is the same. The address is the same, so on and so forth. So here's what the letter states. Now, in this case, must have been getting numerous written demands. I changed my letter up just slightly, but nothing too far off from what this says. It says, I am again in receipt of suspicious demands. Since these papers do not bear a signature and are not accompanied by validating documentation, I have no means to evaluate their integrity. How often does that happen? Have you got anything in the mail from the IRS, Erica, ever?
Yeah.
Does it ever have a signature or validating documentation?
No.
No. It's just a threatening letter. So this is what he says. I object to those under your direct supervision sending me threatening letters without clear identification of who sent the letter and their authority to do so. To enable me to determine whether the threatening letters are frauds, I request that you send me an assessment for each of the following years. And he's got 7 or 8 years listed there. If I do not hear from you within 30 days of the verifiable receipt of this letter disputing a tax obligation for the years in question, I will reasonably conclude that there are no assessments for the years referenced and shall expect your internal investigation to determine who violated laws by sending the threatening letters and will also request a refund from the treasurer. Thank you in advance for respecting my right to dispute a tax obligation. Okay, so that's the first step. The second step is you send a request for a refund to the Secretary of the Treasury, which this one here was Paul H. O'Neill. It is now Secretary Yellen, Janet Yellen. Okay. So in my letter, it was very short and sweet. I request that you refund all sums taken from me for, quote, quote, taxes. Since agents purporting to represent the Treasury have repeatedly refused to document and verify that I am a taxpayer owing a tax, I am without a means to know how much of my money your agency has taken, for what alleged years, or anything else. Since I am deprived of a means to know what your representatives want, I am simply asking that you refund all sums taken from me. Okay? This is the argument right here,
Right.
people.
That's it.
You guys have refused to document and verify that I am a taxpayer owing a tax. That's essentially what the Steve Emerson petition does. So if you look up the code, you guys, if you look up the Internal Revenue Code, it states that the commissioner is required to file an assessment for every taxpayer every year and must furnish a copy of said assessment when requested to do so by the taxpayer. So the purpose of the first letter is say, hey, send me my assessments to prove I'm a taxpayer. They fail to do that. Okay, well, I'm not a taxpayer. Now you've just taken money from me. So you now have standing to sue them in a federal district court, and there's not a dang thing that the IRS can do about it because, again, you're putting the burden of proof on them, not the other way around. It's not where you're going into court saying, I'm not a taxpayer. I'm not a taxpayer. No, it's you're saying, I asked for verifiable documentation proving I am a taxpayer. The law clearly says these guys are required to do it, and they are not doing it. What does Randy say about the law? What does Randy say about people? He never asks his public servants to do anything that the law doesn't command them to do. Have you guys heard that before? I know you have, Erica, haven't you?
Oh, yeah.
Yeah. So we're not asking these people to do something that the law doesn't compel them to do. So anyway, that's where we sit with that.
Chris Real is making a good point too, because, all of the research that I've done on the income tax scam, it seems like the resolution that I've come to is like, at a point, you almost have to come to the fact that the money that you spend becomes like your tuition for learning your lesson, that it is a voluntary process and you don't have to go through with it. And it's like this rite of passage into, okay, I get it now, you dirty bastards. Now, rather than requesting all the money from all the years where you voluntarily handed your money in your ignorance, to just accept like, okay, I was making mistakes all these years. I didn't know. Are we still then allowed to be like, hey, I signed under penalty of perjury that I owed you all this stuff. So here you go.
Well, again, remember, what does the law say? Let me see if I can find it because I was looking at it. That's right here. Okay, I'm going to share, or I'm just going to read this. 26 U.S. Code 6203, Method of Assessment. The assessment shall, so in statutory language, when you see the word shall, it is must.
Right.
The assessment shall be made by recording the liability of the taxpayer in the office of the secretary in accordance with rules or regulations prescribed by the secretary. Upon request of the taxpayer, the secretary shall furnish the taxpayer a copy of the record of the assessment. So what does that say?
They have to do it. They have to give you a copy of all of their assessments.
Correct. It also states under 26 U.S. Code 6201, Section A, the secretary is authorized and required to make the inquiries, determinations, and assessments of all taxes imposed by this title. So does that say that we can make our own assessment and sign under penalty of perjury?
No.
No, it does not. So to answer your question, Chris, and to answer your question, Erica, you don't need to do any of that. Ask for the assessments. And when the assessments cannot be provided because they don't exist, now you have standing. Now you have grounds go, okay, there's nothing here that proves I'm a taxpayer. They took money from me. I want it back. In Alaska, grown, when you sign the W-4 withholding form, you are certifying you are a taxpayer. That is actually incorrect. This is a myth, and I wanted to dispel this myth right here. They're trying to convince you that you're a taxpayer. However, guess what the courts have held? W-4s, W-2s, things of that nature are not prima facie evidence. Because what does the code say? I just read it.
Right.
They are required. The commissioner is required to do the assessment, not you. So even if you have your employer who forces you to sign a W-4 like mine does, it does not mean you're a taxpayer. Does not mean you're required to file taxes. You still have to go down this road. So I just want to put that out there. But anyway, wow. Again, this happens every time. 30 minutes into the show, and we're just barely getting to the topic.
That was a whole different show. Okay.
I know. So traffic stops. Let's talk about traffic stops. Have you guys So when I was talking with Erica about this, when she's like, so what's the she's like, what's the topic of the show? And I said, traffic stops, what to do when you're pulled over. She's like, oh my gosh, that's going to be great, because I've been pulled over like 35 times.
Yeah, I have.
Yeah, why don't you tell us some of your stories, because it sounds like you've had quite the experience there.
They're mostly for speeding.
Sure.
But I have a lot of really random weird ones. Like one time I had a car full of really beautiful women, and I am 100% sure that the police officer pulled us over just so that he could that's all that happened. There wasn't any other reason that he pulled us over. One time I was on a really well-lit road, and I forgot, it was at nighttime, and I had forgotten to turn my headlights on when I started my car, because I had an old car that didn't automatically do that. A lot of really random weird ones, like my plates were expired and I hadn't had a sticker on there, or, just like, tail lights out, but mostly for speeding.
Yeah. So it seems like speeding is the culprit, right? And I'm sure that the same is true for most of you people that are listening or watching. When you get pulled over, it's, usually because of some type of an infraction, right? You didn't stop at a stop sign, or you failed, you ran a red light, or you were speeding, or something of that nature. I'm not talking about, minor car accidents with another motorist. I'm not talking about stuff like that. I'm talking about situations where you're just driving down the road, minding your own, look in the rearview mirror, flashing lights come up. You're like, oh, great. So you pull over because that's what we're told to do. And that's what you should do. I'm just here to tell you, I'm not saying don't you ever to just take off. That's not what I'm saying. If you see flashing lights in your rearview mirror, pull to the side of the road. I mean, we do the same thing if it's an ambulance or a fire truck that's trying to come down the road to get to an emergency. Now, what do you do when the officer pulls up behind you, gets out of their vehicle, and comes up to your window? Okay. I want to be very clear in this, and I know there's been some recent things that have happened. We were talking before the show, Eric and I. Many of you probably have seen, there was a horrible, horrible incident here in Utah, actually, where a young man, I believe he was 24, 25 years old. He wasn't very old at all. He was driving around. He didn't have license plates on his car. So that's essentially why he was pulled over. Now, again, I'm going to be very clear here. You don't have to have a license plate on your car if you don't want it, unless you want to deal with the harassment that you're going to get. So again, you have to be prepared to have these battles. If you're prepared to have the battle and go through it, then you can. And I'm going to talk about, I'm going to talk about a document here that's available. I'm going to save it into our Telegram group, but I got this from kirkslawcorner.com. You guys, I've had Kirk Pendergrass on before. He has a library there where he has some documents, about the natural law and stuff. And we're going to talk about the Treatise on Arrest and False Imprisonment, which was written by Charles Wiseman. He also has another document called The Authority of Law, which is a really good one. So what do? The officer comes up to your window, and How does it typically go, Erica? What do they typically say to you?
Good afternoon, ma'am. Could I please see your license and registration?
There you go. So the first thing they're asking for is your driver's license and your registration. Now, are we required to carry a license and to register our car? I'm asking you, Erica, because you're the only guest on the show today.
I don't think we're required to if we're just traveling and passing through, but yeah, I do think there's something somewhere about needing to provide identification of some sort.
So
upon request of someone.
Yes. So this is where it gets really sticky. Okay. So the whole idea behind a driver's license was, again, the state can regulate commerce, right? So the whole idea behind a license was, well, we need to be able to have a way to regulate individuals who are transporting goods and services on the roads for commerce.
Right.
So Batty Mom of 3 says not engaged in commerce. Correct. You're not technically engaged in commerce. However, how well has that worked out for anyone when they said, I'm not engaged in commerce? You're going to get the deer in the headlights look from these officers.
They don't know. These police
They have no clue.
No idea.
They have no clue because, again, I told you guys, I work with law enforcement, good people. They didn't get into this to harass people. They didn't get into this profession to violate people's rights. They have just been woefully and inadequately trained on what is the proper procedure. So if you say, I'm not engaged in commerce, they're going to be like, so? Don't care. Give me your license. Because they think that we the people are all required to carry a license. Now, I'm here to tell you, I carry a driver's license because I don't want to be harassed. So if I get pulled over and an officer comes up to me and says license and registration, I'm going to hand them my license and registration, and I'm not going to say a word. Here you go, my license and registration. Typically what happens after that is, and I don't know about you, Erica, is it usually like, well, do you know why I pulled you over?
Sometimes they say that. Sometimes they just go back to their car and do whatever it is that they do for like 10 minutes.
Yep.
Probably running something or checking something before they come back. And then you're just sitting there like,
what's going on?
Detained.
Yep. So I'm here to tell you what they're doing is they're running your driver's license. They're running your license plate to see if you have any open warrants for your arrest. They're checking your car to see if it's been stolen. So that's what they're doing when they go back to their car. Because again, I know I work with law enforcement. That's what they do. So when they come back, if you're the upstanding citizen like most of us are, and they come back, they'll either do one of two things. They'll either have a ticket in their hand and hand it to you, and you'll be on your way, or they're going to try and come up with something of, do you know why I pulled you over? And this is what I told my daughter. My daughter just started driving last year. She's 16, and I said, sweetheart, if you get pulled over, this is what I want you to do. When the police officer comes to your window, and they ask you for your driver's license and your registration, go ahead and give it to them. If they start asking you questions, you can do one of two things. And Batty Mom of 3 hits the nail on the head here.
Mm-hmm.
I carry a valid driver's license, insurance, and registration, but I do not answer questions. That's exactly what this young man did when he was pulled over by the police. I think there was an ulterior motive there. This is just my theory. I don't have there's no confirmation of this. I think because of who his family was and their history with the city that they lived in, I think there was something else to it. It wasn't just this traffic stop. But he said, I don't answer questions. What I've told my daughter, which I feel like is the better approach, is ask the question of the officer, can anything I say be used against me?
That's a really great recommendation. Yeah.
Right. So Erica, you're the cop asking me, do you know why I pulled you over? And I'm going to say, can anything I say be used against me? How do you have to respond to that?
Well, if I'm going to arrest you, right, for some reason, it's a part of the Miranda rights. I have to by law tell you that anything that you say can and will be held against you in a court of law.
Correct. So what do we have the right to do? For those of you who are listening, we just did the zipper thing over our lips. You have the right to remain silent. Okay? That's your Fifth Amendment protected right. Okay? So you ask the question of the police officer, can anything I say be used against me? Well, yes. Okay, then I choose to remain silent.
And then it puts them in a really weird, awkward social situation.
It's going to. They're going to be like, okay. So now everything, again, right? Because they have the onus is on the moving party to prove their claims. So now they have to prove that you are A, operating in commerce, and B, are subject to the commercial code, and C, committed an infraction of the commercial code. Right?
Right.
But again, if you just shut up and just say, well, here's my license and registration. Can anything I say be used against me? Okay, I choose to remain silent. Any question they ask you, well, where are you going today? I choose to remain silent. Well, where do you live? I choose to remain silent. They can't ask you who you are because you've already identified yourself with your license and driver's license. Now, every state has some type of a law with this whole identification thing, because you brought this up a little bit ago, Erica.
Yeah.
Here in Utah, the statutory law states that an officer may only ask your name, address, and date of birth if he has reasonable articulable suspicion. There we go. If he has an articulable suspicion that you will have A, committed a crime, or B, about to commit a crime. Are traffic violations crimes, guys?
No. There's
no.
party.
How many times have you gone to a traffic court and they says, well, this is an infraction. This isn't a crime. Well, then what am I doing here? Right? So they say this is an infraction. It's no different than if you were to walk into Walmart and they were to slap you with a fine for violating one of Walmart's policies. That's how it is. Yeah, Batty Mama 3. Status offenses? Correct. Status offenses. So, Chris, we may have to have you on the show, but I believe you had posted some stuff in the group. He says they didn't like that when I said that, and it all went downhill from there. I'm sure it did. This is why I'm going to tell you. You need to be the adult in the room. You need to be the cooler head.
Mm-hmm.
If you say, I'm exercising my right to remain silent, now they're going to do one of two things. They're either going to be smart and go, okay, this guy's a smart. We'll just give him his ticket and send him on his way. Or they're going to escalate it. They're going to say, step out of the vehicle, sir. Right?
Roll your
window down, sir.
I would love to do what you're requesting, but could you please show me the warrant to be able to search the vehicle signed by the magistrate?
Yeah. So there's a couple things you can do in that case, right? You can do like what Erica just said. I'd be happy to do that. Would you please produce the warrant for my arrest? Now, again, I'm of the opinion less is more. So if they're giving you a command to get out of the vehicle, I would ask the question, am I being detained?
Right.
Am I being are you arresting me? Am I being detained? And they're going to have to answer yes or no. Well, you're not complying with my commitment. And again, I'm not. Don't stand on the side of the road and have an argument with these guys, because it's not gonna end well. It's not. But you want to make the record, because these days, most of them have a body camera. You have every right to take your cell phone and record the conversation, and even the video of it. You have every right to do that. So they say, oh, geez, Chris, we're going to have you on, buddy, because this sounds like, oh, dear. So Chris said that they pulled him over for speeding, and he was trying to argue that it's not a crime. They wanted me to step out. He locked the doors, and they were threatening to break the window. Yikes. Oh boy!
Argue roadside. That's it's number one rule. You don't save the arguments for the courtroom.
It's not the place to do it. Again, this is why I'm saying be the adult in the room. Assert your rights to remain silent. If they give you an order, comply with the order. Sir, step out of the vehicle. Okay. Does the officer have any authority to ask you that? No. Are you required to comply with that? No. But what's going to happen if you don't, Erica?
It's going to become a power struggle is what's going to happen.
Exactly right. And you've got somebody who's on a power trip because they wear a badge, they have a gun on their hip, they've got another deadly weapon with a taser. So I'm just telling you guys right now, just comply. Now, what are you to do if you are exercising your right to be armed? You need to inform them, okay, before you step out of the vehicle. Now, I don't carry my firearm with me all the time, but sometimes I do. So if it happens to be the situation where I have my firearm with me and I get pulled over, again, I'm going to say the same thing. I'm exercising my right to remain silent. If the officer asks me to step out of my vehicle, I'm going to say, officer, I am going to comply with your request under duress. You should know I am armed. I'm going to keep my hands where you can see them as I get out of the vehicle. Or if you have your firearm in your vehicle, you should let them know that. Okay? Again, this is cooler heads prevail, right? We don't have to get to the point where, like this poor young man who refused to get out of his car, the officers were trying to break open the window. Probably, I don't know if that happened to you, Chris, but then one of them said he saw a gun. There's still speculation that there was even a gun in the car. We don't know. But the point is, you had 6 officers opening fire on this kid, and he was killed. So cooler heads need to prevail in these situations, and this is how we do that. So what happens then if you are detained? Well, first we need to understand what does that mean, okay? So for those of you who are listening, I have on my screen here, I'm going to pull up to the screen, to the title page. This is a treatise on arrest and false imprisonment by Charles Wiseman. Okay, and from what I can gather, it looks like he lived in Minnesota because a lot of this stuff is related to Minnesota. So in this document here, he's got a number of contents: being arrested, the use of warrants and arrests, defenses to unlawful arrests. He's got a whole bunch of good stuff in here. I'm not going to talk about this entire because this is 80, I think it's 80 pages long. I'm not going to talk about this entire book, but I'm going to talk about a couple of things. So the first is false imprisonment. So when I say that, what comes to mind to you, Erica? What does false imprisonment mean to you?
Keeping me in a place that I don't want to be in.
Okay. So basically restricting your right or your liberty to be able to go where you please and how you choose. Does that sound about right?
That sounds about right.
Okay. So under the definition of false imprisonment, this is what Charles Wiseman says. He says, false imprisonment consists of any type of unlawful restraint or interference with the personal liberty of an individual. It basically involves any unlawful violation of the liberty of another. The ancient English legal scholar, Henry de Bracton, and this guy lived back in the 1200s. That's when the Magna Carta was signed. Okay. He tells us that false imprisonment is one of the oldest violations of rights known. To forcefully deprive a man of freedom to go wheresoever he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. Okay? So, at the basis of it, false imprisonment is any unlawful detention of another individual, preventing them from going about as they may. So let me ask you, when you get pulled over by a cop and he pulls you over because you're speeding, does that constitute false imprisonment? Erica, you're shaking your head no.
I don't think so.
You don't think so?
If he pulled, well, I don't know. Probably it does. If they're detaining you from being able to move about, if it's longer than a certain amount of time, I guess maybe that would be my answer. Yes.
C to AZ. Yes. Okay. C to AZ, you would be correct. It is unlawful imprisonment, because let me just bring your attention over here. Unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. Actual seizure or the laying on of hands is not necessary to constitute an unlawful detention.
Okay.
Thus, the only essential elements of the action are two things. Number one, detention or restraint against one's will. And two, the unlawfulness of such detention or restraint. Okay? Now, they're going to argue, oh, well, we had every right to pull you over because you violated the speeding code.
Right.
Okay. Can you please go ahead and submit to this court the undeniable evidence and proof that that code was written and pertains to me? Where is your evidence? Right? So let's talk about this. He's got in here, I'm going to scroll down through here a little bit. And guys, this is a great read. It really is a really good read. Like I said, I'm going to save it in our Telegram chat. But if you want to look at it before then, go over to Kirk's website, kirkslawcorner.com, under his library. So we talk about an arrest without a warrant. Okay. Chris, for real, I'm going to go out on a limb here and see maybe that they arrested you. Maybe you can confirm that for us in the chat. I'm not sure. So what does the law of the land say? The authority to arrest without warrant was rather limited and well defined at common law, a law which has been part of our constitutional law in the due process provisions. The common law rule on arrest is based on common sense. So Chris he confirmed that he was arrested. Okay. So Chris, this right here, this is going to be a copy and paste for your situation, quite literally. Okay. So the following material is to help the citizen in protecting his liberty from unlawful encroachment by executive officers. First, to initiate a suit against one who unlawfully deprives you of your liberty. And there's an example of a summons and complaint. There's also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that has existed for hundreds of years on this matter. So this is really good. Again, this is all here. You guys can copy and paste it and use it. The only difference is here, he filed this in a state court, which, when you look at his causes of action, so false imprisonment is a cause of action, and that's a state law claim. You can actually tack onto this Title 42, 1983, deprivation of rights under the color of law. And you can take it to federal court if you wanted to. Okay. So let's look at the complaint, because this is really good. Let me see if this, and Chris, I don't know your situation, but maybe as we're going through this, you can put in the chat, this is, oh my gosh, this is exactly what happened to me, or very close to it. Okay. Plaintiff for his complaint against defendant states and alleges. Number one, on September 30th, this is clear back in 1992, by the way, people. Plaintiff was traveling in his automobile on a public highway called I-35 West between Richfield and Minneapolis, going northbound, when stopped by the defendant acting as a highway patrolman, an employee of the state of Minnesota. The defendant asked plaintiff to see his driver's license. The plaintiff explained that he is not a licensee under any board or commission and is not required to be a licensee. He is not wrong. Supreme Court has stated multiple times that the right to travel is a right that you can carry, and you do not have to have a license to do it. Okay? The defendant insisted that plaintiff must have the said license. The defendant then arrested, searched, and handcuffed the plaintiff without a warrant, and over his objections that defendant's acts were in violation of plaintiff's rights and the constitutional provisions of due process of law. Now, again, I don't know what he said when he said it. Like I said, less is more. But sometimes it's like, hey, you should know you're violating my rights. You're violating the due process, my constitutional provisions of due process of law.
And if they don't know before this incident, they'll know after.
Exactly. The defendant gave no specific charges to the plaintiff for his being stopped or for the arrest, nor did he advise him of his rights as shown in the defendant's field report, which contained only traffic misdemeanor charges. A copy of this report and an official complaint was received by plaintiff 2 months after the arrest. The defendant brought the plaintiff to Hennepin County Jail, where the defendant knew that the plaintiff would be subject to booking, which included fingerprinting, photographing, and confinement for an indefinite period of time and possibly be subject to other types of assaults and batteries. I mean, that is so true. The guys that work in these jails, I mean, they just think everybody that comes through the door is a criminal, which, 90% of the time they are, but there are those situations where they're not. Further, the plaintiff, by his own admission, made no attempt to bring the defendant he has this wrong. Further, the defendant, by his own admission, made no attempt to bring the plaintiff before a magistrate or judge when he had full opportunity to do so, being that the arrest occurred about 10:15 a.m. on a Wednesday. That is what is called a probable cause hearing. It's a constitutional provision. It's a due process of law provision. Every state constitution has it. Mm-hmm. Okay? If you are arrested without a warrant, the arresting officer is required to take you immediately before a magistrate judge. And they have to say, this is what happened. This is why I effected this arrest. The judge is supposed to make a third-party determination that, yes, you had probable cause, or no, probable cause does not exist. Release this individual. Okay? That alone right there happens 99.9% of the time. They never do that.
Right.
So the defendant, acting on his own accord and without warrant or court order, had the plaintiff's automobile towed to an impound lot and put it on a hold order. Okay? Count 1, false imprisonment. The defendant, without warrant or due process of law, see, and here's the constitutional provisions, unlawfully arrested the plaintiff and, acting contrary to law, did falsely imprison the plaintiff, depriving him of his liberty. As a result, the plaintiff had his right to liberty violated, suffered mental anguish, a loss of time and wages in his work, and a discredit in his reputation by his failure to attend a scheduled meeting. Number 2, the defendant, upon arresting plaintiff, brought him to the county jail for the purpose of booking and detaining him, and by his own admission made no attempt to bring the plaintiff before a proper judge or court as is required by due process. Number 3, assault and battery. Due to the unlawful acts of the defendant, the plaintiff suffered a series of assaults and batteries upon his person, including arrest, handcuffing, imprisonment, physically searched, forced fingerprinting and booking procedures, and harassment. Now, he's only seeking $10,000. Again, I'm just going to tell you right now, that's a drop in the bucket to these guys. He is suing this guy in his individual capacity, which you need to do, but you need to sue them in their individual and official capacity, because then their employers on the hook for it as well. And this is how we make these changes. This is how we effect changes to these things. So let's look at the memorandum of law on arrest without a warrant. Okay, so Chris says, asking about his situation, he said, they did say I had to have the license, and that is one of the charges. So they're charging you for failure to have a license. Okay, so what you need to do, Chris, is you need to look at the definitions of that statute, and you're going to find something along the lines of person means an individual, a natural person, a corporation, something of that nature. So that statute is designed for what is often known as artificial persons or legal persons, which is not you, the human being. That would be like your business or something else like that, or if you're operating in commerce. Okay, it's really difficult there, but you can see where I'm going with here. And when I would strongly suggest you review this, this document here, and these, excuse me, this memorandum of law on arrest without a warrant, because it hits the nail on the head. So it says here, comes now the plaintiff, a free citizen of the state of Minnesota, who respectfully presents and submits this memorandum as evidence and proof of the prevailing and controlling law regarding the matter now before the court. Okay? He says the defendant claims that his arrest of plaintiff without warrant for the violation of 2 traffic laws was lawful. Defendant claims that he is authorized by statute to make arrests for any violation of laws of the state, whether they are a misdemeanor or a felony when committed in his presence. The facts of this case lead to the conclusion of law that the defendant did not have any lawful authority to arrest the plaintiff. The defendant had no warrant for the arrest of the plaintiff, and he alleges that he only saw plaintiff commit a misdemeanor, i.e., a traffic violation. There was no claim of a felony committed or of a breach of peace committed. There was no claim, at common law and under the provisions of due process of law, such an arrest without a warrant cannot be made. Since the arrest deprived the plaintiff of his liberty by an act not pursuant to due process of law, the arrest is unlawful. Due process is not determined by the legislature. Okay, you need to get that in your heads, people. Due process of law is not determined by the legislature. Okay, here's a case that he cites here. He says, it is manifest it was not left to the legislative power to exact any process which might be devised. The due process article is a restraint on the legislative as well as on the executive and judicial powers of government, and cannot be so construed as to leave Congress free to make any process, due process of law, by its mere will. You're going to hear judges, officers, they're all going to say, well, the legislative process says this, the legislative process says this. That's not how this works. Go back to your state's constitution. Go back to the federal constitution. Look what it says. And he harps on that here. He says the Constitution of Minnesota declares that no person shall be deprived of life, liberty, or property without due process of law. The words due process do not mean anything which the legislature may see fit to declare to be due process of law. And here's the state. Anytime you want to make an assertion in any of your court documents, back it up with an authority. So he did that right here. The state ex rel v. Billings, 1893. Due process was intended to preserve established fundamental rights by requiring that they cannot be deprived except by the established modes of law as existing under the common law. This guarantees that the government shall follow a specified and pre-existing rule of conduct, process, or procedure is in itself a right the citizen held at common law and was claimed by the colonists in early America. Thus, it is clear that the common law is the foundation of that which is designed as due process of law. So then he talks about, okay, what exactly does due process of law? Because I've often asked this question. I mean, Erica, have you ever asked this question? What exactly does due process of law mean?
Right. It's a good question to make sure you understand it, since they refer to it all the time.
Yep. So there's a number of cases that cite this. And he says, in interpreting what due process of law is, it has been held that none of our liberties are to be taken away except in accordance with established principles. Thus, the mode of arrest by which one can be deprived of his liberty is to be determined by the pre-existing common law principles and modes of procedure. A properly constituted warrant of arrest is a process at common law by which persons could lawfully be deprived of their liberty. The common law on arrest without warrant recognized only certain specific and well-defined cases whereby a citizen could be deprived of his liberty. This cannot be abrogated or changed by the legislature. That is key. You're going to see the legislature in every state say, well, you can effect an arrest because of this. You can effect an arrest because of this. No, they cannot. It says here, the common law drew a distinction between an arrest for misdemeanors, such as that which the defendant arrested the plaintiff upon, and arrests for felonies. When a felony was committed, an arrest could be made without a warrant, but no arrest could be made for a misdemeanor without a warrant unless it constituted a breach of the peace. The misdemeanor traffic violation was not a breach of peace, and thus the defendant needed a warrant to make an arrest for such an offense. Okay? Chris, I'm willing to bet that that's exactly what happened in your case. Can you confirm that?
That's what I was getting ready to say. Did you breach the peace, Chris?
Yeah. Was the reason you were stopped a breach of peace? So let me ask you this, Erica. You're driving down the road. Let's just say it's a 2-lane road. Speed limit's 45 and you're going 52. So you're speeding technically. There's no one around. You come around a corner and there's a sheriff's deputy sitting behind a sign, pulls you over. Have you committed a breach of peace?
I don't think so.
Who else was potentially harmed by your actions? Anyone?
No one.
There was no one else on the road besides you. That's not a breach of peace. Okay? In determining the law surrounding arrests, the Supreme Court of South Carolina affirmed a prior decision of the court holding that, at common law, as a general rule, an arrest could not be made without warrant for an offense less than felony, except for a breach of the peace. The fact that the defendant believed the plaintiff committed a misdemeanor and had charged him with a violation of the traffic law did not authorize him to arrest the plaintiff. In a New York case, the state city alderman or justice of the peace could not, at common law, arrest or cause an arrest for a misdemeanor not amounting to a breach of peace without the warrant, though happening in his presence. This is what they said. They said at common law, an arrest could not be made of a person charged with a misdemeanor except on warrant of a magistrate, unless it involved a breach of the peace, in which case the offender might be arrested by any person present at its commission.
Citizen's arrest.
There you go. In the very well-reasoned and authoritative case of Ex parte Rhodes, the Supreme Court of Alabama related the due process provision to the act of arrest. It asserted that any seizure or arrest of a citizen is not reasonable or due process merely because a legislature has attempted to authorize it. These phrases are limitations upon the power of the legislature as well as upon that of other departments of government or their officers in determining what was due process. Regarding arrests, the court stated, it must not be forgotten that there can be no arrest without due process of law. An arrest without warrant has never been lawful except in those cases where the public security requires it. That is what the breach of peace means. And this has only been recognized in felony and in breaches of the peace committed in the presence of the officer. So Chris says he was peaceful. They didn't even charge him for speeding. You're going to have some fun with these people, Chris, because you got a lawsuit right here. And the only way these things change is if you follow through with it.
Right.
So he states further here that the Alabama Supreme Court went on to say that the phrase due process must be determined by what it meant at the common law and when the Constitution was adopted. The court then cites the case of Tillman v. Beard, stating officers are justified in arresting without warrant only in cases of felony and breaches of the peace. This is elementary. It is needless to cite authorities. So you're going to have, you go up against these attorneys, these prosecutors for these towns, they're going to throw, well, the legislature says this, the legislature says that. But you need to go back to your state's constitution and look, because every state's power and authority comes from who? Where did they get that authority from?
The consent of the governed. The
consent of the governed. Okay? We, the people, like the banner behind my head. So for those of you who are listening, I have it's a picture of we, the people, of the Constitution. We, the people, hold the power, and we delegate that power to ensure our rights are protected. But we never delegated the power to allow executive officers or members of the executive branch, like police officers and sheriff's deputies and state highway patrolmen or troopers or whatever, we never delegated the authority to them to be able to arrest anyone because they feel like it. Okay? Did you see recently, Erica, there was a video out of Wisconsin where two young men were standing on the sidewalk reading passages from the Bible, and they just happened to be near an event that was going on, and I'm not going to say what that event was because I don't want to get in trouble, but they were arrested and removed because of it. Did you see that?
I don't see anything but plants and animals.
Okay, so just to bring you up to speed, they had every right to do what they were doing. They committed no crimes. Nevertheless, the police officers came, confiscated his microphone and his speaker, handcuffed him, and forcefully removed him from the public property. So you guys, this doesn't end until we step up and say enough is enough. When I say we, I mean more of us. I'm fighting the battles that I can fight that are happening to me personally and to those that I know that are confident enough to stand up and fight these battles. That's why I'm taking on my property tax issue. That's why I'm taking on the IRS issue. Those hit home to me. Now, if something like this happens to me, if I'm driving along, minding my own business, and heaven forbid, I'm handcuffed and taken to jail for something I didn't do, I'm going to fight that battle then, and I'm going to stick it to them where it matters. But if more of us don't do this, nothing's going to change. So Chris says he's preparing a notice to carry in his car for these instances. Chris, more power to you. I'm here to tell you it's going to mean nothing. It's going to fall on deaf ears. Nothing's going to change until you stand up and you fight back, and you fight back using the power of the pen. And you go after these people in the courts. And that's why we have our Telegram group. We're happy to help. We'll do the best we can. I want you to take the first stab at it. I want you to take the documentation that's there for your use that you can use. Use that as a template. Write up your complaint. You saw that complaint that Charles Wiseman stated. It was 2 pages. Mm-hmm. It doesn't need to be 35 pages of this and this and this and this. You don't need all of that stuff. Less is more. That's one thing about Dr. Graves. You know, when we've had him on and we talk about his courses, he says, you know what? You don't need to have a 40, 50, 60 page complaint. I mean, if it's detailed about crimes and things of that nature, or civil RICO, like I have in my property tax suit, like Alphonse has in his, then yeah, it does need to be that long. But if it's just something simple like this, depriving you of your right to your liberty, that can be 4 or 5 pages long. And then submit a memorandum of law with it. And then go, okay, the burden of proof is on you guys to prove that this statute applies to me. Yes, Chris, in the form of an affidavit. Correct. Because again, I want to harp on this a little bit too, because I've been having some conversations with people in the group about jurisdiction. Remember, jurisdiction is a 4-legged table. And in order for any order from that court to be a lawfully binding order, that court must have all 4 legs. Do you remember what those legs are, Erica? I'm testing your knowledge here.
In personam, jurisdiction. In
personam, yep.
Subject matter.
Subject matter.
Locate, not location.
Yep. You're right. Territorial.
Territorial jurisdiction.
Mm-hmm. Do you know what the last one is? And just to be clear, the last one generally only applies to actions involving your property. So that should give you a clue.
Okay.
It's called in rem jurisdiction.
In rem jurisdiction. Mm-hmm. Okay.
Yeah. Yep. Thanks. So the courts must have all 4 of those things. Otherwise, the table falls. So I've been chatting back and forth with an individual in the group, and I'm not sure his or her name. They just go by the initials J.O. And their concern was, well, if I start cross-examining, I'm going to consent to their jurisdiction. So you can waive personal jurisdiction. You can waive that all day long, but you can never
waive subject.
Can never waive subject matter jurisdiction. And what is subject matter? That's the jurisdiction over the issue at hand. So in Chris's case, if the charging statute is a traffic violation, well, what does the statute say the subject is? Well, the subject is a legal entity organized and created under the statutes and codes of the state, because under the definitions, this is what it states. Well, the prosecution has offered 0 evidence to this court to suggest that I am any of those things. And in light of that, absent that, the court is wanting subject matter jurisdiction, but it does not have it. That's how we have those battles.
That's the process that you take. So let's say you get through the entire traffic stop without bringing a breach of peace, and and becoming a felon at that point that can be arrested without the warrant. Let's just say you just quietly say, I'm sorry, I don't answer questions, and then you get your ticket. Then you can take that ticket and not even go into court, right? You can just send in the information that you're motioning to dismiss it based on lack of their subject matter jurisdiction.
Exactly. And that's exactly what I would do. So I'm going to give you a little example. Last week, we went up to a recreational lake that's near here. It's about a couple hours away. And what's interesting about this lake is the state line between Idaho and Utah goes right through the middle of the lake. So we drive. So if you can get your picture in your mind, we drive from the west, and the lake is like a big oval, runs north and south. And the beach we were going to go meet up with some family was on the east side. And the easiest way to get there is to go through Idaho and come back down. You're actually technically still in Idaho. Well, my wife didn't know this, but apparently it's a state park and you had to pay to park there, to go there. But when you came into the entrance, the guard station or whatever, where you would pay, there was nobody there. And she didn't think two things of it. She just pulled through and parked. And well, we get this, for lack of a better term, a ticket on our windshield that says you now need to pay $20 plus the parking fee because you didn't do this. We're like, I didn't know I needed to do this, and it didn't even cross my mind. And then it says, if you don't pay this within 48 hours, you're going to get a citation. I'm like, ooh, please.
Don't
please
tempt
go ahead.
Good time.
Don't tempt me. So I'm kind of leaning towards, because I want to have some fun with this, I'm leaning towards, go ahead, issue that citation. Let's see how well this works out for you. Because again, I don't ever ask anybody to do anything I'm not willing to do myself. So in this case, and in your situation you're talking about, like if you're pulled over and the guy gives you a ticket, what I'm going to do, what I would do, take a copy of the ticket. I'll look at the moving statute that they're moving under. I'll review it, and I'll write up a motion to dismiss for lack of subject matter jurisdiction. I'm going to cite the other stuff too. I'm going to cite the courts must have all jurisdictions in order to be able to issue binding judgments, blah, 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 blah. Cite my authorities as along with that. I'm going to cite that there's no in personam jurisdiction. I was never properly served with a complaint, so I was never given notice. There's no subject matter jurisdiction because according to the charging statute, the subject of this are entities organized and incorporated under the statutes of the state. I am one of the people of Utah. I am not one of those things. And I'm just going to put the moving party in this case, the prosecution, has offered no evidence to suggest that I am any of these things. And that in light of this information, this court must dismiss this action for want of jurisdiction. And I'm going to leave it at that. Now, if they choose to be stupid, which I'm sure they will, and keep trying to move along, well, guess what? Now I can go after these people for malicious prosecution. So we'll see what happens there. But I digress. So that's what I had for today, everyone. I hope it was good. Like I said, I'm going to drop that treatise on arrest and false imprisonment in the Telegram group. Matter of fact, I'm going to do it right now so I don't forget. And then for those of you who want to review that, I strongly suggest you do. It's a very good documentation. Like I said, Chris, this is where you're going to want to go. Okay. Looks like you said you had to pay a $2,200 bond to get out of jail. Yeah. Again, this is where you're going to want to go, because those are all going to go play towards your damages. Okay. If you don't have Dr. Graves' course, get it. The howtowinincourt.com. If you go to the pinned articles in the group, there's a link there. With that, you guys, thank you so much. I do want to thank you guys for some of you have offered suggestions of guests to come on the show, and I appreciate that. Keep doing it. Our next show, we're going to have a guest come on, and I haven't talked with her just yet, but I do want to talk about her. I do know it has to deal with family law, and that's an area of major concern for a lot of people. So, any closing thoughts you want to close out with, Erica, before we end the show?
just always the same reminder that, you know, I was reminded again yesterday when I met with a police officer in the community at a restaurant. And when he's not in his uniform, he's just a regular man who wants to talk about cornhole and beach volleyball and stuff like that. And if you can always just be trying to connect with the soul of the person behind the uniform, whether it's a banker or a lawyer or a police officer or, someone working in the courthouse, and you're just connecting with who they are, you're always going to have a better luck in whatever it is that you're going for, because ultimately what they've done is they've created this really beautiful system where we're all the prisoners and the prison keepers.
Mm-hmm.
Right?
Yeah. No, it's the truth. I mean, it's a sad reality, but it is the truth.
The prison keepers don't know they're prison keeping. They don't even know they're in prison too. So it's like, if you interact with people with that compassion and that knowledge of just knowing that they don't know either. Mm-hmm. And then, you just always make sure to use the time that you have when you're interacting with someone, not to make the situation worse. It's all about timing. Roadside education is never a good idea, ever.
Yeah, it's not usually going to bode well for anybody involved.
Right. Look for opportunities to meet your local police in settings where you're not being pulled over by them.
Yeah. Well, one of the things I like to do is, again, because I work with law enforcement, and so I'm fortunate enough that I have a corporate card. So if I'm eating at a restaurant somewhere and I see a uniformed officer come in, I always buy their lunch. And I want them to know, hey, I appreciate the things you do. We're appreciative that you're willing to put your life on the line to protect us in our community. That's the situation that Eric is talking about right there, where that's a setting to have that discussion and say, hey, are you aware? What would you do in this situation? And just talk about and just have a conversation. So
those are the best conversations I have, because as a nurse, you have to remember, like, we are constantly working with firefighters and police officers and security officers, and they're our brothers and sisters. And so there's a bit of a rapport that's developed, a brotherhood and a sisterhood among first responders like that. But just making a point to always remember to connect with men and women as such, and not to let their stations, their positions within the prison systems, to make us go head to head with each other.
Exactly. Great point. All right, everybody. As usual, I'm going to ask you, a little shameless plug here. Like our videos, subscribe to our channel. It helps us to get the word out. I do want to thank all of you, though. We have on our YouTube channel, we have surpassed the 1,000 subscribers. So thank you, everyone. That is so nice of you. We are on a weekly basis. We're interacting with somewhere between, 2,000 to 3,000 people, which is, that's a small number, but it's growing. Gosh. Considering we started this show in February this year, whenever that was, That's impressive. That's very impressive. So I want to thank all of you for this. Keep on fighting the good fight. We love you. We're here to help you. Again, ask any questions you have. Take the first stab at it, because, again, the only way we win our republic back to the way it's supposed to be is when we are educated and we know this. So,
right.
Take care, everyone. Hopefully we'll see you all for next week on next Thursday. We'll talk soon.